Hi, this is Attorney John Roach, and I wanted to make a short video for other lawyers about whether they should do a mini opening in a personal injury jury trial. There's 3 reasons why you should want to do a mini opening before voir dire. Number 1, it gives you the opportunity to preview your bad facts so that when you're exploring whether the panel has potential bias about your case, you're not talking about a vacuum, but you're talking about the particular pieces of evidence that you have concerns that a juror who has bias may come out and damage your case. For example, I had a case where a plaintiff had a felony conviction that was going to come into evidence. So in my mini opening, I said to the jurors, one of the things you're going to decide in this case is whether a mistake in my client's past, where he was convicted of a felony, did his time and was rehabilitated, whether that means that he's entitled to less civil justice, money compensation, than someone who has not been convicted of a felony. Now, there's other examples of bad facts that you may want to preview to the jurors. For example, you may have small property damage in an auto collision. In that situation, you may want to preview the photos to the jurors in your mini opening so that when you're talking to the jurors in voir dire, you can say, is there anyone who thinks based on those photos that there's no way my client could prove her or his case? Now, a second reason why you absolutely want to do a mini opening in a personal injury jury trial is because you get to talk about money. I think it's always a good idea to start off and tell the jurors that this is a multi-million-dollar case and you're going to be asking for that amount of money. And you can be precise or give a range. But under CCP 222.5, a lawyer has a right to probe jurors about potential bias. And as we know, a lot of potential jurors have bias against awarding multi-million-dollar jury verdicts, even when the evidence supports it. So it's a good idea to talk about money before you do your voir dire. A third reason why you want to do a mini opening is because it allows a great introduction to voir dire. You get to tell the jurors that if there's any reason why you can't be fair to the defense because of some reason, then as much as we want to win this case, we cannot have you as a juror on this case because we want a fair fight. Now, if you have any strong feelings about multi-million-dollar jury verdicts, well, that may mean that you cannot be a fair juror in this case where the plaintiff is going to be asking for multi-million dollars in a jury verdict. So, dig deep, jurors. And if there's some strong feelings or something about your past where you view the facts in this case through a lens that favors the defendant or the plaintiff, we cannot have you as a juror on this case. And then when you get into voir dire and you bring up brutal honesty, you can ask the jurors to be brutally honest with you about the facts that you've revealed that this case is about. And I think that leads to a much more productive discussion in voir dire. So what does a mini opening look like? Well, I like to write out my mini openings in advance, practice, and film myself. So I'm going to read my mini opening from my last jury trial, Wilkinson v. Hudson, that happened in Napa. This case involves a car collision that caused an elderly man chronic neck pain. On December 15, 2017, defendant Natalie Hudson passed Mr. Wilkinson on the left as Mr. Wilkinson was attempting to make a left turn into a parking lot, causing a crash. These are the photos of the property damage. Now, Mr. Wilkinson did not go to the emergency room. In fact, his first medical visit was about 3 weeks after the collision. Mr. Wilkinson has been in a subsequent collision after the accident with Miss Hudson. In addition, Mr. Wilkinson has experienced 2 or 3 falls after the accident. The evidence and the law the judge will give you in this case will justify a verdict of at least $1 million for the pain and suffering and loss of enjoyment of life damages Mr. Wilkinson has suffered and will suffer in the future as a result of this collision. It will also decide the question of economic damages. How much money will go to the medical providers in the future to pay for the treatment that Mr. Wilkinson will require in the future as a result of this collision? The defendant admits she was negligent, but disputes the nature and extent of the damages Mr. Wilkinson is claiming. What we're looking for is jurors who are going to give both sides a fair fight. If there's anything about your experience you've had in life or opinions that you have that will give us an advantage over Miss Hudson, as much as we want you to win, we cannot have you as a juror in this case, because the defendant will not get a fair fight and a fair trial. If there's anything about you that makes you have a distaste for multi-million-dollar jury verdicts for pain and suffering and personal injury cases, that will give the defendant an advantage over Mr. Wilkinson. And Mr. Wilkinson will not have a fair trial. So please tell us, dig deep. Tell us if having you on a juror on this case will give one side an advantage over the other, so that we can come together and find 12 jurors who are neutral and won't see the evidence through a lens or filter that favors one side over the other. Thank you.